'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop.
Mike D coming down for sure.
We looked at law and the different kind of national legal systems that we can see, as well as some classification systems that are used for us to understand what kind of law we're dealing with. We're now going to look specifically at how the Australian legal system works. Now, obviously, this is quite complex, and you can do your thesis on this particular topic. So we're going to cover the main topics that go a long way to explaining why things are done the way they're done. It also hopefully gives you a sense of the importance of the rule of law that we discussed last time. This idea that people in power within Australia must act within the boundaries of laws that are in place, right? They're subject to the laws and are not making arbitrary rules or judgments per se. We're going to deal specifically with the principles of government with a little explanation of why we have those principles and what they mean. Okay, so let's hop into the Australian legal system. So a critical factor that often we gloss over is the fact that Australia is a federation. So what does that mean? It means that the states came together to form the nation. They were colonies at the time, but they came together to form the nation. So that means that power is shared between the Commonwealth and the states. While we talk about the Australian government, which has its capital in Canberra, that kind of glosses over the fact that the 6 states and the territories particularly the states, have lots of their own power. You see, they originally had all of the power as a colony and gave that up, some of those powers up to the nation, which is where we end up at the moment with power split between these two governments. Now, I know what you're thinking. Well, some of you might be thinking, but isn't there also a local government? Yes, there are local governments, but they're actually delegated legislation, right? The state government has a legislative framework in place that allows them oversight. Well, the councils get their power from the state government. See, that's very interesting. That's why the state government can jump in and intervene in council matters. But the federal government can't intervene in state matters, and the state government can't really intervene in federal government matters. It's a little more complicated than that, but power-wise, that's how the system's set up. It's very difficult just to present a very brief summary of an entire nation's legal system. However, there are 6 key defining features that we need to go through. The first one, hopefully we've been through, is a federation. The second one that we've been through is this idea that we're part of a common law system. The third hallmark of Australia's legal system is that we're a liberal democracy, in that the people who make the law and who actually run the government or in charge of the executive are elected. Okay. So they're not there from hereditary, or they're not there because they hold a position in a political party, etc. They're there because they're elected. Additionally, as part of a liberal democracy, even those people elected are subject to the rule of law. Okay, so they have to abide by the laws that are in place within the country. So we're a representative democracy where elected representatives exercise power subject to the rule of law. We're a common legal system based upon the British legal system. We're a federation, right, in that we have a national government, but there are also state governments. And the state governments, notice this, they're not subordinate to the federal government. In fact, power is shared, and we're going to come to the importance of the Constitution to that. Now, you may be aware that the head of state is the Queen at the moment, Queen Elizabeth II, represented by an official. That official at the federal level is called the Governor-General, and at the state level, it's a governor. As we saw from the common law system, this is largely a ceremonial role. and that the governor or governor general takes advice from the government of the day and enacts the legislation based upon the government of the day. If we went into a lot of detail, we could say, well, there are a few wrinkles in that, but essentially they're there in case something goes wrong in the system. So whoever gets appointed to the role of Governor General or Governor is by convention an independent person of all political parties. When I use the word convention here, it has a very specific meaning. It means that there's no law that says that that's the way it is, but that's the way everyone agrees to operate without there being a specific law that you could point to. So the final two hallmarks in the Australian legal system are the separation of powers and the principle of responsible government. These two are actually related. In essence, the principle of responsible government says whoever's running the executive or the government, the arm of government that runs day-to-day business should be accountable back to the people. And so the way that we do that in Australia is a minister will run a department, a part of the executive government, and that minister has to give account back in Parliament to all of the representatives of Parliament who represent the people. So that's kind of what responsible government is, but it's entwined with the separation of powers. So let's have a look at separation of powers. The separation of powers is a fairly simple concept, and it just says that you don't want to concentrate power in one group or individual. Strictly speaking, what that means is that no person should be in the legislature who makes the law, in the executive who administers the law, and in the courts who judge the law, right? Because if you can develop the law, put it into practice, and then judge whether it's right or wrong or how to interpret it, then actually you have absolute power. And the idea of law doesn't make any sense, because you could write a law and then you could interpret it. You could apply it however you wanted and then interpret it however you wanted to fit what you've actually done. So without a separation of powers, we run into a problem that maybe we don't actually have the rule of law. We'll deal in more depth with the separation of powers later, but it essentially says, the doctrine of the separation of powers says we should have a separate legislature, executive, and judiciary. Now you'll notice I talked about responsible government, where I said it's a minister who's elected, who actually runs it, who's in the executive, is also in the legislature, right? They report it. So we do not have a strict separation of powers between the executive and the legislature, but we do with the judiciary, and that's the check and balance. So there's this trade-off, right? We might not have a strict separation of powers, but what we get instead is responsible government. You can contrast that with a country like the US, where in fact they have a stricter separation of powers, right? The executive is the president, right? And the president appoints the people who they want to actually run the government. It's a very different system to what we have in Australia. So if they're the key hallmarks of the Australian legal system, the next question is, why do we operate the way that we do? And we've got a brief introduction into how our legal system evolved, primarily looking at why the state government has certain powers and the federal government has certain powers, and also going to give us a look at how the judiciary can actually interact in our legal system to alter the law, and why being a common law system, therefore, is such an important element of our legal system.